Up until now, we've been talking about contracts under the common law. We're going to switch gears now and talk about contracts under the Uniform Commercial Code. The difference under the Uniform Commercial Code, we are going to deal strictly with contracts involving the sale and leases of goods. All other transactions are covered under the common law. So when we're talking about the UCC, we're going to be talking about the sale and lease of goods. So state statutory law, the Uniform Commercial Code, and it's uniform. It's every state has a uniform commercial code. The goal of the Uniform Commercial Code is to simplify and streamline commercial transactions. So sales and leases, they're governed under the Uniform Commercial Code is a very big code. And the transactions involving the sale and leases of goods are found in Article 2 and 2A. Article 2 governs sales, Article 2A governs leases. And it doesn't govern all of commercial transactions. We're just talking about the sale and leases of goods. We're going to discuss other articles throughout the course that come under the Uniform Commercial Code under different articles. So Article 2 governs sales, and not only sales, but sales of goods. What is a sale? The passing of title from the seller to the buyer for a price. That is a sale. Okay, what is a sale? The passing of title from the seller to the buyer for a price. So what's a title? A title refers to the formal right of ownership of property. And what is price? That's the cost. Is it cash? Yes, it could be cash. Could it be goods? Sure, it could be goods, and it could be services. So that's the price. So we have a passing of title from the seller to the buyer for a price. Under the UCC, they have a definition of goods. And this is it. All things which are movable at the time of identification to the contract for sale other than the money in which the price is to be paid. Well, that's a mouthful. So let me start with the tail end of that, and then we'll work through the components. The other than the money in which the price is to be paid, that is a investment security. So that's going to be under Article 8. So we're going to be focused on all things which are movable at the time of identification to a contract for sale. And then other than the money in which the price is to be paid, that if we're dealing with money, we're going to be dealing with that under a different transaction, okay? Under Article 8 of investment securities. So let's talk about some definitions here. Tangible, the movable at the time of their identification to a contract. So we have to have a tangible good. So on the advice of a number of friends, Annie visits her local bookstore where she buys a copy of the book, the next Harry Potter installment. The question is that governed by Article 2? Is this a sale of goods? Yes, it is. The book is movable at the time of identification to the contract for the sale. The sale is happening in a bookstore. Annie's buying a book. The book is the goods, and it's identifiable at the time of the transaction. How about Hector has an exercise bike that he never uses, and Cleo has been given an expensive hammock that she doesn't want. And the two of them agree to exchange. If something arises, conflict arises, is this governed by Article 2? Yes, it is. The hammock is a good. The exercise bike is a good. It's movable at the time of identification to the contract. Who's the buyer and who's the seller? They're both buyers and sellers. Hector is the buyer of the hammock, but the seller of the exercise bike. Cleo is the seller of the hammock and the buyer of the exercise bike. This is a contract that would be governed under Article 2 of the UCC. You can identify the goods and then at the time that the contract is made. Because of amazing demand, the bookstore runs out of the book and must contract to buy larger numbers of copies from the publisher. Is this a transaction governed under Article 2? Yes, it is. The agreement, the contract between the publisher and the bookstore contracts for a number of copies of the books. So you don't just need one good, it could be a bunch of goods that are identifiable at the time of the contract. What if the publisher informs the store that all previous printings of the book have been completely sold out and that it will fill the order only when the later printing is completed sometime next month? Is that governed under Article 2? Do we have a movable at the time of identification of the contract? No, the books aren't identifiable at the time of the contract. We call this future goods. The books are future goods. They're still considered goods. The UCC defines future goods as still goods. These are goods which are not both existing and identified at the time of the contract. But what's happening in my example is there's a contract to sell. So if the publisher informs the store that all previous printings of the book have been completely sold out and that it will fill the order only when the later printing is completed sometime next month, and the bookstore agrees, they have an agreement that the publisher will sell books to the bookstore when the next printing comes. So this is a contract to sell. So it's a contract, and it will be governed under Article 2 because future goods, which is the books, are still goods under the UCC. We call that a contract to sell. And when the books become available, then it's going to be a sale of goods. Okay, what about this example? Author of the book, J.K. Rowling's. She's hired to give a series of lectures and speaking engagements on the book by an organization in New York City. Is that a contract? Yes, it is a contract. Is it a contract governed by Article 2? No, it's not. It's a contract for services, so that would be governed under the common law. So to be characterized as a good, we have to have tangible property. It has to have physical existence. Book, car, washer, oven. It has to have physical presence. It has to be tangible. These are movable, and they can be carried from place to place, and they're governed by Article 2. Stocks, patents, bonds, copyrights, these things are intangible, and they cannot be seen or touched. They exist only conceptually. And stocks and bonds, they're governed under investment securities, which we're going to get to later this semester under Article 8 of the Uniform Commercial Code. Those are not governed by Article 2. So tangible versus intangible. Goods have to be tangible, physical existence, be able to move from place to place. So J.K. Rowling holds a copyright in her book. She enters into a contract with movie company to make a movie of the book, giving the company the right to use the book's story. This would not be governed under the UCC. That's intangible property, her copyright in the book. What about real estate? Let's talk about goods associated with real estate. What is real estate? Land, any interest in property, easements, right-of-ways. We have things that are permanently attached to land, trees, plants, sheds, barns, homes, We talked about contracts involving real estate under the common law. Real estate's not a movable good, right? Can't be moved from place to place. It's not. It's, I guess, tangible if you sit on it or stay in one place, but real estate is covered under the common law. So I decide to move out of my rental apartment and move into a large home. I enter into an agreement to buy a house at 789 Widget Lane in Plattsburgh. Is that governed by Article 2? No. It's real property. Real property is not movable. It's governed under the common law and real estate law. Now, my property includes a large wooded lot. And as part of the transaction to sell my house to buyer, we also agree that the trees will be logged or cut and the wood sold prior to the sale, and the price reflects this in the agreement. So is the contract for a sale of goods in that regard, having that separate component. We're cutting trees down and taking it off the property. Governed by Article 2? Yes. Now we're dealing with real property, but items that are coming off of real property that are now movable. In my example, the timber, if it can be severed from the property or extracted from the property, it's a transaction governed by Article 2. Contracts involving timber, we have minerals that might be extracted, gas or oil. Those would be considered tangible goods that are movable, and therefore it's a sale of goods governed by Article 2. So what about goods? One more example. J.K. Rowling is going on a world tour. She needs foreign currency. She contracts with a dealer and arranges to buy 10,000 euros. Is euros goods under Article 2? Yes, it is. Tangible property. That can be moved. That's movable, and that's governed by Article 2. Bob contracts with Sally to buy a Cocker Spaniel from Sally's Pooch Emporium. Live animals, they covered? Yes, the animals are livestock, and animals are goods under Article 2, so Article 2 would govern that transaction. Would it matter if the contract was for a puppy not yet born or not yet conceived? No, because it's future goods. You'd enter into a contract to sell, and then when the puppies are born, it changes to a sale of goods. So no, future goods in that case still govern under Article 2 for a sale of goods. So what happens if a contract is for both services and goods combined? We know that contracts for services are not governed by Article 2. You hire a clown for your kid's birthday, it's a service contract. It's not governed by the UCC. But what happens when the contract's for both? Bigelow decides to fix up the kitchen in his bungalow. He enters into an agreement with Hammer for the construction and installation of a new set of kitchen cabinets. The specifications call for a particular type of knotty pine and designated brass handles and hinges. The agreed upon price is $3,000, which covers all materials and labor. So, does the UCC govern the situation? Actually, it doesn't. There is no provision in the UCC that says, hey, if you have a contract that is mixed services and goods, the Article 2 covers or doesn't cover. We don't have anything like that. So what happens is the court had to make a decision of what happens in that case. And what do we have here? We might, if a issue arises in this case, Bigelow might say it's a sale of wood and hardware, and if there's a problem, the UCC governs because those are goods. And Hammer might say, whoa, it's a construction service contract. You hired me to fix the kitchen. So what happens? How does the court decide? They answer this question: whether the transaction was predominantly for the sale of goods or for service. So in this case, we call that the predominant factor test. The court asks this question. So it's kind of like all or nothing approach, and this is what most courts use. So it's either going to be a sale or it's going to be a service. They're not going to combine it. Everything's going to be included, okay? One body of law will govern. So in this case, what is this more like? Bigelow decides to fix up his kitchen in his bungalow. He enters into an agreement with Hammer for the construction and installation of a new set of kitchen cabinets. And the specifications call for a particular type of knotty pine and handles and hinges. In this instance, it's probably more like a service contract. The hiring, the point was to hire for the construction of the new kitchen. And in order to do that, you have to have wood and brass handles and such. So this is more like a service contract, which means, does UCC Article 2 apply? No, the common law would apply in this case. But what if Mr. Bigelow goes to a local carpet store and picks out a style of 100% wall-to-wall carpeting for his living room. He buys it from the store for a price that includes installation by the store's personnel. If he later finds that the carpet is not all wool as described, can he bring a lawsuit under Article 2? We have a mixed situation here, service and goods. We have the installation and we have the carpet, but in this instance, it's the carpeting that is the most important aspect. So this would be governed under Article 2, even if the issue involved is the installation. It was installed improperly. The Article 2 is still going to apply. Doesn't matter where the issue arises. It matters what is the contract predominantly about. And in this case, with the carpeting, it would be about the goods, which is the carpet. Therefore, the UCC Article 2 will apply. So, to the example that's now on the screen. Wimpy goes into a local diner and orders a hamburger and dines there. Is this governed by UCC Article 2? What do you think? We got a hamburger, some fries, and a drink, and he dines right there. Governed by UCC Article 2? Food, is it goods? Movable? Tangible? Yes, food sold in restaurants is governed by Article 2. What if he went through the drive-through? Yes, that would still be governed as a sale of goods. Off premises or on premises. Food, it's tangible and it's movable. So yes, food counts. Even if you're being served in a restaurant, the food being brought out to you. It's predominantly for the purchase of lease of goods. So Article 2, sale of goods. Article 2A, lease of goods. So consumers, businesses, business firms, they lease. You can lease automobiles, industrial equipment, many other types of goods. Many airlines rent all or most of their planes in their fleet. Major manufacturers regularly enter into multi-million-dollar lease deals for massive pieces of equipment. We have consumer lease deals. We have small businesses that lease office equipment. So what's behind this? Why do we have this lease of goods? Mostly for tax consequences. This is a very modern business environment here. They like leases. No one wants to buy anything. In my office, I lease a copy machine. I don't have any use to buy one or own one, and when I don't need it anymore, then I send it back and I stop paying for it. So, Article 2 governs leases. It was created in 1987 and it was amended in 1990, and it is essentially a repetition of Article 2, except it says for lease of goods versus sale of goods. But all of the other rules apply. It is a mirror image, basically. So we'll cover leases right now, and when we move forward, when I say sale of goods, I also mean lease of goods. I'm not going to keep interchanging it and saying it. When I say Article 2, I also mean Article 2A. All the same rules apply, but let's talk about the differences between the sale and the lease. So when is a lease a lease? The UCC as a definition defines it as a transfer of the right to possession and use of goods for a term in return for consideration. And we have a lessor and a lessee. We have more names that come about here. One who transfers the right to possession to the leasee is the lessor, and the one who takes possession of and uses the leased goods for a price is the lessee. Now let me see, do I have an example on this one? Yes. So Professor Brock, exhausted after a hard year of dedicated teaching, decided to take a vacation. And he goes to Arrow Rental Car and arranges for a month-long rental of a fairly new luxurious sedan, which he agrees to pay for $1,000. This arrangement a lease? Yes, it's a lease of goods. It's governed under the UCC Article 2. This is a consumer lease. So we have a couple types of leases that we talk about: consumer lease and a finance lease. The consumer lease everybody is familiar with. When a lessor leases goods to an individual primarily for personal, family, or household purposes, and that total lease payments have to be less than $25,000. That's a consumer lease. It could be car, it could be furniture, it could be, what else? Mostly people lease cars, but you can get various equipment, such as washer and dryers under lease. I don't know why you would, but you could. And the use has to be personal, family, household, and less than $25,000. This other concept was created as a business necessity: finance lease, where the lessor acquires the goods or the right to them from a supplier and leases them to a lessee. Now, that sounds like an odd picture. Try and visualize it. Why would a third party enter the picture? So basically we have a business that acquires goods. They can either buy them outright or they can lease them from a supplier. Usually they buy them outright. They'll buy them outright, and then they lease them to the third person. Why? Why don't you just, if you want goods, you buy them? A wants to sell goods to B. B wants to buy goods from A. Why would we have this component? Maybe B doesn't have the money to buy the goods up front. A could agree to sell to B on a credit, right? But A probably wants their money up front as well. So, and then in the manufacturing world, manufacturers are not always in the position to extend credit on a single large sale over what could be many years if we're talking about a big, large piece of equipment. Their business is making goods and selling them. They depend on those big chunks of cash to come in so that they can produce the next item. So usually, either a lender comes in. I like to think of this finance lease. The financing party is brought to the table so they can buy goods from A and then lease them to B. Think of it on a small scale, my copy machine example. There's this company that buys copy machines, and maybe they also do the upkeep on them and fix them as part of their business. So they go out to various makers of copy machines and buy copy machines. They could be low level $1,000 ones to $50,000 ones, depending on what the need is and what the use is. And then they go and they lease them to businesses. That's how I have my copy machine. And I have, when there's a problem, I call up the place and they come and they fix it. and I lease the copy machine. When I'm done with it, or when the lease ends, it goes away, or maybe I get an upgrade. But the point is, I don't have to buy a copy machine, or if it broke, and I have to buy a new copy machine. So that's one example, and that's a nice, easy example to picture how this finance lease works. But big companies certainly do it when they're dealing with big manufacturing types of machinery. But let's not get it all confused. And I also don't want it confused with a security interest. If you buy something from someone, like a car, and then they hold the security interest in it, that is not a lease. That's not this type of finance lease situation we're dealing here with. We're talking about someone who owns it and then leases it out and then they take it back. So now we have this component of a merchant, something we didn't have under the common law. Article 2 governs the sale of goods in general. Okay, so between all buyers and sellers, each and every person selling and buying goods. So when we transact with with each other, you want to come over and buy I'm selling my car. You want to buy it. That is governed by Article 2. If you buy and sell things on Craigslist, on eBay, it's governed by Article 2. Okay, you don't have to be anybody special to have your contract be governed by the UCC. However, there are provisions relative to certain sellers and buyers, and we call those merchants. So there's some special rules for these unique sets of players. And we call them merchants, and the definition under the UCC, and I'm going to say there is no guesswork, by the way, involved in deciding who is a merchant. The code specifically makes it clear in a particular statute. The statute will say and use the word merchant. We don't have to decide whether a particular situation, someone we think of as a merchant. It'll say, if you are a merchant in this blah, 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 blah situation, this rule is going to apply to you. It specifically says it. So who's a merchant? It's a person who deals in goods of the kind involved in the sales contract and who, by occupation, holds himself or herself out as having knowledge and skill unique to the practices or goods involved in the transaction. Now that's a mouthful, but that's the definition that the legislators wrote out. But let's talk about an example. Ned is a lawyer, and he is the proud owner of a purebred female Cocker Spaniel that he arranges to have mated with a purebred male owned by a neighbor. When the puppies are born, he posts a handwritten puppy for sale notice on a bulletin board around town and places a small ad in the local paper. Josie contacts him for a puppy and makes an agreement to buy a puppy for $500. Does Article 2 apply here? Yes, Article 2 applies. Puppies are goods. So the transaction between Josie and Ned is governed by Article 2. Is Ned a merchant? No, Ned is not a merchant. He's not a person who deals with puppies and holds himself out as this unique breeder. He's a proud owner of a purebred dog, and he arranges to mate the dog with a neighbor's dog. There's nothing special about this arrangement. It's not his job. So in this case, it's governed by Article 2, but he's not placed in a different sort of position for being a merchant because he's not a merchant. But it turns out later that Ned, while keeping his lawyering job, expands his dog breeding activities considerably, and he now owns several females that he regularly breeds and advertising and selling the offspring under the name Spaniels of Springfield. Is this different? This is slightly different because now he would probably fit that definition of a merchant. It's while he's still being a lawyer, he's holding himself out as having knowledge and skill that's unique to this practice and the goods. He's grown it. He's created a name for it. He's operating it just like a business that he has special knowledge doing. So in this instance, Ned would be deemed a merchant. Now, switching gears, the drafters of a sales contract and a lease, there's special types of contracts that are governed. But Article 2 contain, I want to make sure we've talked a lot of concepts under the common law. And all of those concepts, those general contract principles, offer, acceptance, consideration, all apply under the UCC as well. The UCC hasn't changed that. Article 2 hasn't changed that. There are some slight unique situations that I'm going to pull out the differences of with regards to offer, acceptance, consideration, and such, and where they come into play in the UCC. But you have to understand that Article 2 contains the common law as a general contract principles. Okay, so that's the overall, and the UCC has created some unique modifications relative to those, okay, and how they've changed some of the laws. And that's what I'm going to show you here, some of the differences. One of the big differences is something that we call open term contracts. When we talked about the common law, you don't need every single essential term to be in an offer or an acceptance or ultimately the contract. There are some terms that may or may not be there, and there might be an essential term that's left open that may deem the contract unenforceable. The UCC has kind of flushed those out. Offer. So we're going to start with the offer. Under the UCC, sales or lease, remember now I'm going to use them not interchangeably, but I'm going to refer to sales. But you have to remember that also means lease. So under the UCC, sales contract will not fall for indefiniteness, even if one or more terms are left open, as long as, and we have these two rules, parties intended to make a contract, and 2, reasonable certain basis for the court to grant an appropriate remedy. So as we know, under the general contract law, contracts form when a definite offer has been made and met with an unqualified acceptance. So you asked me to buy your bike for $100. I agree to buy your bike for $100. Okay? Under general contract law, that is a contract. There's an offer and acceptance. We have an agreement to buy the bike. What if we have an agreement to buy a bike, but there's no mention of price? What if we have that example? If we had the agreement to buy the bike, no mention of price. Do we have a contract? Offer must be definite enough for the parties and courts to ascertain its essential terms when it's accepted. Under the UCC, is this governed by the UCC? The bike? Yes, it's a good, so we're in the UCC. Under the UCC, a sales, a lease contract will not fail for indefiniteness, as long as the parties intended to make a contract. There's a reasonable certain basis for the court to grant appropriate remedy. So we have an open term, and the open term is the price. Would you decide whether a contract is made here under these rules? Let me give you some UCC provisions. The UCC provides numerous open-ended provisions that can be used to fill in the gaps to a contract. Okay, so we're dealing with the UCC because we got a sale of goods. So if the parties leave out the price or allows the parties to determine it at a later time but can't, or a third party is to determine the price and doesn't, what can the court do? Under the UCC, the court can set reasonable price at the time for delivery. The court will set a reasonable price at the time for delivery. Delivery of what? the goods. So it's fair to say that the court must know what the amount we're dealing with, but we'll get there in a second. Let's go back to our bike. In this instance, we don't have a price listed, but we have a contract, right? The parties intended to make a contract, sell the bike, buy the bike. We don't know how much. When the bike's delivered, it's probably, what would you say the reasonable price would be? The fair market value. The contract will not be void if the court can, one, show that the parties intended to make a contract, and two, reasonable certain basis for the court to grant an appropriate remedy. The court can set the reasonable price at the time of delivery. You deliver the bike tomorrow, maybe there's a document that says what the value of the bike is. Call a local bike store. Oh yeah, we'd sell that bike and it's worth $100. So it won't fail. The contract won't fail without not having the price under the UCC. So the court will set a reasonable price at the time for delivery of the goods. I'm going to sell you widgets and you agree to buy widgets from me at $1 a widget. I'm going to sell you widgets and you agree to buy widgets from me at $1 a widget. Do we have an open term? We do. What are we missing? Amount of goods. Can that be fixed? The parties intended to make a contract. Sure, I'm going to sell you widgets and you're going to agree to buy them from me at $1 a widget. So we got number one. What about number two? Is there a basis the court can grant appropriate remedy? How? Or how? No. No, it can't. What's it missing? We don't know how many widgets. How can the court say what it is, how much it is, how much you owe, or how many widgets you have to buy, right? So if the open term is about the amount of goods, according to the UCC, the quantity of goods must be involved and expressly stated. If it's left open, there's no basis for determining the remedy. So, at the very least, you need the quantity. So, let me change my example. I'm going to sell you 100 widgets, and you agree to buy 100 widgets from me. Is that a contract? Yes. We intended to make an agreement. Can the court determine how much the widgets are going to be? Yeah, they're going to take the reasonable value at the time of when I deliver the widgets to you. Probably be set by the fair market value. So, the point is, if you don't have things like your delivery time, your price, your mode of delivery, these terms can be determined. And they're going to be determined as to what is reasonable. Remember our objective standard? We're going to hear that objective standard throughout this whole course. What is reasonable? So if there are missing terms, not the quantity, you need the quantity. If there's no quantity, you don't have a contract. But if there's other missing terms, it's not going to deem your contract unenforceable. The court is going to set what is reasonable. So here are the rules. Open price, reasonable price at the time of delivery of the goods. Quantity must be expressed. All other instances determined by what is reasonable. So those are our rules relative to the offer and acceptance, or the offer component. When people enter into the contract of what you need. What if a party has power to decide an open term? If a contract for the sale leaves it to one party, the power to specify a particular means of performing. One person gets to decide time, price, mode of delivery. It's an open term to be determined by Mr. A. Is that okay? So if a contract leaves it open to a party to decide a particular term, it won't invalidate the contract. Parties can agree to leave the determination of a specific term to a specific party as long as any such specification must be made in good faith and within limits set by commercial reasonableness. We make an agreement whereby you purchase 100,000 widgets from me for $200,000. The contract provides that you will state when and how you want them delivered. Is that acceptable? Would that be an acceptable agreement? Yes. Is it governed by Article 2? Yes. It's goods. For the sale of goods. What if you say I want them in a week, but you want them shipped by Amish buggy? Is that reasonable? Commercial reasonableness? Is that made in good faith? Maybe. Maybe you want to support the Amish, but is that commercial reasonableness? Probably not. What if the commercial standard is a tractor trailer for widgets delivery? So the rule is going to be determined based on commercial reasonableness and good faith of the person who gets to decide. Our merchant has special rules with regards to offers. An offer, if you remember, as we know under general contract principles, an offer can be revoked at any time before acceptance, even if that offer promises to keep it open. Remember, there's no consideration. I promise to sell you my car for $1,000. Let me know by Friday, and I'll leave it open until Friday, and it's Monday. And on Wednesday, I call you up and I revoke it. Can I do that? Yes, because there's no consideration for me to leave it open. I can, even if I promised. I broke my promise, oh well. But a merchant, there are some other rules. Under the UCC, there's an exception for the merchant. They call it the merchant firm offer. An offer by a merchant that is irrevocable without consideration for a period of time. The firm offer must be in writing and signed by the merchant offerer. And if no time is specified, like the merchant doesn't say, I'll leave it open till Friday, if no time period is stated, it'll expire at the end of 3 months. So no longer than 3 months, okay? And it's only the offerer who is the merchant in this instance, okay? The offeree doesn't have to be a merchant. They could be a merchant, but they don't have to be a merchant, okay? So the offer can be revoked at any time unless the offerer is a merchant and the offer not to revoke is made in writing, signed, and with a specific time, and if there is no specific time, no longer than 3 months. So let's take an example. Sam, a used car dealer, offers to sell a certain 2000 Chevy to Beth for $1,000. She tells him that she can't make up her mind right now. Sam says to her, "Don't worry, I'll keep the offer open for the next week. You can accept any time until then." The very next day, Beth decides to buy the car, but before she can get over to Sam's, she receives a message from him on her answering machine in which he says that he has decided not to sell the car to her at this price. His message concluded with, "I would sell it for $1,200. Can Beth get the car for $1,000? No, she can't. Why not? Even though Sam is probably a merchant, his firm offer is not in writing and signed by him and with no specified period. So she can't. Suppose that at their initial meeting, Sam has scribbled on a memo pad bearing his company's logo the following. Quote, "Offered to sell 2000 Chevy to Beth for $1,000, good for 1 week as of today. The only other marking on the piece of paper was the day's date." Does that change your answer? It shouldn't. She still can't get it for $1,000 because he didn't sign it. Consider Bonnie, a bank president, drives her car into Sam's looking to sell it. She is asking $2,400. Sam says he'll consider this deal, but only if she signs a piece of paper he writes out that says Bonnie offers to sell her car to Sam for $2,400. This offer remains open and irrevocable for a period of 1 month from today's date. Sam dates the paper and asks Bonnie to sign it. Is Bonnie bound by this offer? Can she revoke before that month's time's up? She is not bound. She can revoke any time before the month is over. Why? Because she's not a merchant. Now, what if Bonnie herself was a dealer of automobiles and not a banker? She would have to be bound by that offer because now she's a merchant. The offer is in writing. It's signed by her and it expires less than 3 months. There's an expiration date on it. So that is a merchant firm offer and it would have to remain open. We move on to acceptance, where an offer doesn't specify the means of acceptance. The UCC provides that acceptance can be made by any means of communication reasonable under the circumstances. So the UCC permits acceptance to an offer to buy goods for current or prompt shipping, either by a promise to ship or by prompt shipping of the goods to the buyer. Let me repeat that. The UCC permits the acceptance to an offer to buy goods. So we got an offer to buy goods for current or prompt shipment, either by a promise to ship. So the offeree can say, yep, I promise to ship, or by prompt shipping of those goods to the buyer. So either or will act as acceptance. But what is reasonable? But a communication can be made whichever is reasonable under the circumstances. So what if the seller does not promise to ship the goods that the buyer orders, but instead ships something completely different? Well, first let's do our acceptance. I send you an email offering to buy 1,000 widgets from you at your cheapest rate. How can you accept this? Any reasonable communication. Maybe you email me back. Maybe you call me on the phone. Maybe you ship me 1,000 widgets with the bill that shows me that's your cheapest rate and how much it is for 1,000 widgets. So you can either accept by a promise, which you would relay in any commercial reasonable fashion, or by promptly shipping the goods. Now, Macintosh orders 5,000 red headphones from Hayden. Hayden ships 5,000 black headphones that he has in stock. Hayden doesn't tell Macintosh. Is this acceptance? If we were dealing with the common law, this would be considered a counteroffer, right? No, I don't have red headphones, but I got black, right? But under the UCC, this is acceptance. Hayden has accepted to sell 5,000 headphones to Macintosh. But also, what do we have here? We have a breach. It's not the right color. Macintosh certainly can sue. We'll talk about remedies and the opportunity to fix the issue. Oops, I didn't mean to send black. I'll send you red and I'll pay for the expenses. Yes. But by prompt shipping, because by prompt shipping of goods, that's permitted under the UCC, but it's the wrong color headphones. What if he tells Macintosh? What if he calls him up, says, oh, I just shipped you out black headphones instead of red. I don't have red here. Is that okay? He says, oh, I'm doing these instead. It's an accommodation. The shipment now becomes an offer. And the contract, this is where our counteroffer comes in, now becomes an offer. And the contract formed when Macintosh accepts it. So under the common law, if acceptance, we know acceptance differs from the offer, we call it a counteroffer, and there's no contract. But in this instance, acceptance is okay upon shipping, but there is also a breach. Macintosh doesn't have to accept those, and it would be at the cost of Hayden. But if Hayden tells Macintosh he's doing so, it's going to be deemed the counteroffer, and Macintosh has to decide whether or not he wants to accept. And now we have this issue, battle of the forms. Now, all businesses have their favorite forms that they like to use. If you remember under the common law, we have this mirror image rule, the acceptance and the offer, they have to mirror each other, they have to have the same terms, nothing new. But in business, everybody has forms, invoices, or sales slips, or receipts, and they rely on these form documents that they have pre-printed for their use. And it details the manner and conditions, terms and conditions that they like to use in their documents. So if one party insists on their form, another party wants to use their form, or the offerer sends something in writing, and then the shipment form comes in, and there's the receipt, and it's got other terms. The question is, well, which terms do we use? Right? Which ones rule? Because now we're not in the mirror image rule, especially if the buyer, the shipper, the one who's sending goods to the offerer in the headphone case, it's gonna come with a receipt. And you can just accept based on shipment. You don't have to say, oh, look at my form, I need to approve your form. So, battle of the forms. The UCC knew it was coming. A contract is formed if the offerer makes a definite expression of acceptance, even though the terms of the acceptance modify or add the terms of the original offer. So let's talk about it. There will be a contract if the offerer or if the offeree makes a definite expression of acceptance, even though the terms of the acceptance modify or add the terms of the original offer. So what happens to these new terms will depend on whether the parties are merchants or non-merchants. Let's talk about when one or both parties are non-merchants. The contract is formed according to the terms of the original offer, submitted by the original offerer, and not according to the additional terms of the acceptance. Okay? It is the mirror image rule, but slightly different. Okay? Remember, the common law mirror image rule is, here's my offer, you have to accept it unequivocally, or we don't have a contract. What this rule is saying is, here's my offer, and if you submit your acceptance on, paper or by receipt or by a invoice, and it has additional terms, we're still going to have a contract, but your terms aren't going to apply. So that's how it differs from the mirror image rule. Let's take an example. I purchased 500 books on the UCC from an online realtor, Books Plus in Michigan. When the books arrive, the accompanying invoice includes an additional term that states any dispute between the parties will be settled in Michigan. And of course, a dispute arises over payment, and Books Plus sues me in Michigan. Am I bound by that? I'm not, because I am not a merchant. Books Plus is a merchant. They're an online realtor specializing in book sales. And then they sent an accompanying invoice, and it has their terms. And one of the terms is this dispute. Am I bound by it? No, I'm not. My original offer is the one that stands. And our second rule is when both parties are merchants. We have to have both parties are merchants. The additional terms become part of the contract unless. So we have our offer, and now we have our acceptance. One is on let's call it a memorandum to order from the offerer for widgets, and the merchant now sells those widgets to the offerer merchant, and they come with an invoice, and there's rules, maybe where to sue if there's an issue. They all become terms of the contract, unless the original offer expressly required acceptance of those terms, the new or changed terms materially alters the contract. So if you're going to buy 100 widgets for $200,000 and the acceptance says buy 100 widgets for $300,000, then that's not going to be acceptance. And the offeror rejects the new or changed terms within a reasonable time. So buy 100,000 widgets for $200,000 to be shipped in 2 weeks. Acceptance, but 1 month shipment is what we'll need. And the offeror says, no way, I need them for a job that needs to be completed in a month. So that's the offeror rejects the new or changed terms within a reasonable time. So if any of those 3 exist, then there'd be no contract. Offer, acceptance, we have our agreement, we have our rules under the UCC. Consideration. Consideration is required under the common law to have a contract and the UCC. Where we run into a difference is when we come to modifying contracts. The difference under the UCC is it will allow for a modification of a contract without consideration. If you remember, under the common law, to modify a contract, you have to have additional consideration unless there is some unforeseen, extraordinary difficulty. That's the only way that a contract will be modified without consideration. But under the UCC, you can modify a contract without additional consideration if the modification is made in good faith. What do we mean by good faith? Good faith means honesty and observation of reasonable commercial standards of fair dealings in the trade. You can't extort from others. That's bad faith. That would be unenforceable. You agree to sell me your bike for $100. I agree. We agree that in 2 days you will deliver the bike and I'll pay you the $100. The next day you call me up because you'll learn that the value of the bike is $500 and you now want $500 for the bike. I agree to pay $500. Following day you show up with the bike and I give you $100. Is this governed under the Article 2, this transaction? Sale of goods? Yes, it is. Do I have to pay you the other $400? Nope, I do not. Even though you're allowed to make a modification under the UCC, modification must be made in good faith. Is this in good faith? Nope, would not be in good faith just because you learn that the value went up. You have to sell me the bike for $100? Yes, you do. Jim agrees to manufacture and lease certain goods to Louis for a stated price. Subsequently, a sudden shift in the market makes it difficult for Jim to lease the items to Louis at the agreed upon price without suffering a loss. Jim tells Louis of the situation and Louis agrees to pay an additional sum for leasing the goods. Governed by Article 2, actually I should say Article 2A, yes, because it's a lease of goods. Can Louis refuse to pay because lack of consideration here? Can Louis refuse to pay more than the original price? Sure, he probably could, but what would happen is Jim would probably not move forward, and then there would be a contract dispute and a breach as such, and then it would have to be kind of duked out. But in this here there's a shift in the market. Is that good faith reason to modify without consideration? Sure, that's a very common one. So in this instance, it was good faith. No bad faith on the part of Jim. The market fluctuated, changing the manufacturing costs. So you need good faith. You don't need consideration, you just need good faith to modify your contract. Statute of frauds. We do have, we talked about it under the common law when we were talking about the 5 types of contracts that need to be in writing or are subject to the statute of frauds. And goods, sale of goods for over $500 must be in writing. And it's the totality of the contract. So if you have a contract for sale of goods priced at $500 or more, it must be in writing, as we discussed the totality of the contract. So if you have a contract where someone is making 5 installment payments of $100 each, the entire contract is $500. So that would need to be in writing. The parties can have an oral contract. However, to satisfy the statute of frauds and to be enforceable, if needed, they must memorialize that oral agreement into a written memo. The writings indicate that the parties intended to form a contract and that it's signed. That's the sufficiency of it, the sufficiency of the writing. It is sufficient as long as the memo indicates that the parties intended to form a contract and it is signed. And it will not be enforceable beyond the quantity of goods shown in the writing. So if the writing says 100,000 widgets, we're dealing with 100,000 widgets. Merchants have a little bit of a different rule. Bert, a merchant buyer in Cleveland, he contracts over the phone to purchase $4,000 worth of goods from Ernie, a merchant seller in New York. 2 days later, Ernie sends written confirmation to Bert detailing the telephone conversation, and Bert receives it. Do we have a contract? Yes, we do. Is it for the sale of goods? Yes, it is. So Article 2 will apply. Does the statute of frauds apply? Yes. It's for sale of goods over $500. So we need it in writing. Do we have it in writing? We do. We have it in writing, the details. But what don't we have? Bert's signature. Do we need Bert's signature? Is Bert bound by this confirmation? He is, if he doesn't give 10 days objection. He cannot say that the statute of frauds, there's a violation of the statute of frauds and get out of a contract. So where the merchants, written confirmation between merchants can satisfy the requirements of a writing for a statute of frauds if after the parties orally agree, one of them sends the other a signed written confirmation within a reasonable time, and that the other receives it and does not object within 10 days of receipt. The missing signature does not matter. This is only between merchants. If we're dealing with a merchant and a non-merchant, or 2 non-merchants, it's the rules that we've already learned under the common law that applies. You need a written contract with signatures from both parties. So in our example, 2 days after they orally agree, Ernie sends the confirmation. That's within a reasonable time. Bert has 10 days to object. If he doesn't, he can't argue for a violation of the, or unenforceable under the statute of frauds. There are exceptions to the statute of frauds. There were exceptions under the common law, and those certainly do apply here. But we have additional ones. Specially manufactured goods. So if we have a contract that involves specially manufactured goods, and it's for the sale of over $500 worth of goods, it has to be in writing. But if it's not, if it's an oral contract between merchants, it's not been reduced to a writing, this oral agreement will be enforced if the following three things are met. It is for goods that are specially manufactured for a particular buyer, or specially manufactured or obtained for a particular lease. I should say leasee. The goods are not suitable for resales or lease to others in the ordinary course of the seller's or leaser's business. And the seller or lessor has substantially started to manufacture the goods or has made commitments to the manufacture or procurement of the goods. Cannot claim statute of frauds issue if all three of these things exist regarding specially manufactured goods. Okay, before I begin with this example, I think I misspoke. Hopefully I didn't, but in thinking it through, I may have misspoke, so I want to clarify something. Specifically manufactured goods. If you have an oral contract between parties, I think I may have said merchants, between parties. They don't have to be merchants. Okay, just so we're clear. So is it a good rule, by the way, before I even start with the example? Basis of the statute of frauds, as we know, is to prevent fraud. So by the very nature, like, don't you think items, it might be hard to believe that there was no contract made. Let's start there before we even get to 1, 2, and 3. Somebody orders specially manufactured goods. It's kind of hard to believe that a contract didn't exist, especially if somebody got started to create a good for someone. All right, my example. There's me, Rebecca Fox, lawyer. I have a design for my firm's letterhead to include other associates that work for me, put their name and everyone's email address on the firm's letterhead. I contact Pam, the printer, who has done work for me before, and I place an order of 25 boxes of letterhead at $30 a box. Pam creates the printing plate with the necessary info and runs off the first box. Before she runs off the others, I call her to cancel. I change my mind. Or maybe I want to make changes. If Pam decides to sue me for breach of contract, will there be any issues? Can I claim statute of frauds? This contract subject to the statute of frauds? Yes, it should be in writing. But what do we got here? Do we have specialty goods? Well, we have letterhead that nobody else could probably use. She probably couldn't resell my letterhead, right? Has she started? Well, she's done one box. Will the court require this to go forward? Probably not. I mean, there's definitely a breach of contract. So will I owe Pam anything? I'll probably owe her whatever cost it was for her to do the printing plate. Probably for the first box that was printed. But Pam, if you remember, I'm going to stretch your brain a little bit. Back to common law. She has to mitigate her damages. So if she just continued to print off more boxes and then held me to it, she's not really mitigating her damages. What if Pam lost a job, another printing job, because she was going to print my job and she didn't have time to do the other one? She might be able to collect there as well. And what if she printed all of the boxes? Would I be required to pay? Yeah, these are specially manufactured goods. They can't be suitable for resale anywhere else. And she's now definitely substantially started, but definitely finished. And I would be responsible, despite the fact that this was never in writing under the statute of frauds. Admissions Again, like the common law, if somebody makes an admission in a court proceeding or a sworn to court document or testimony that a contract existed, then there's no need for the contract to be in writing. And partial performance. An oral contract is enforceable if payment has been made and accepted or goods have been received and accepted. So very much like under the common law. The only addition is the specially manufactured goods, which makes a lot of sense. Especially if the one manufacturing the specially manufactured goods cannot get rid of those in some other fashion. They were made specifically for that buyer for that particular purpose. Maybe it was for a St. Patty's event. And the parole evidence rule. We learned about the parole evidence rule under the common law. It exists here as well under the UCC. If the parties' agreement is set forth in writing, attending to be the final agreement, the terms cannot be contradicted by evidence of any prior agreements or contemporaneous oral agreements. Remember that? No outside evidence is going to come in. Makes sense because of the purpose of the statute of frauds is to prevent fraud. However, under the UCC, the terms of the contract may be explained. The UCC may allow outside evidence to explain or supplement by consistent additional terms or by the party's course of dealing, the usage of trade, or the party's course of performance. So let's talk about some examples here. Actually, what I have for, there's a separate sheet that's in Moodle. It's called Parole Evidence Rule Examples under the UCC. This is where I'm going to have a supplemental video to discuss these terms, but I want to discuss these terms right now, and then I want to put them together in the fleshed out, I think it's 5 or 6 examples, so I'm going to do that under a separate video portion. So the UCC allows for supplemental or for outside evidence to show or explain or supplement consistent additional terms to a contract, to show course of dealing, usage of trade, and course of performance. Now I'm going to give you some rules, and then I want you to go back, pull out that sheet, print out the sheet, and go through the questions before you watch the video. Maybe I want you to try and figure it out with these rules, and then watch the video relative to it. So, consistent additional terms. This is actually same as common law. If the term is ambiguous, the court will accept evidence to clarify the ambiguous term, as long as it doesn't contradict the term or other terms. So that's going to be allowed. Course of dealing. Okay. This is the parties in the contract's course of dealing. So the key is what their prior dealings were before this agreement. So it's a sequence of previous conduct between the parties to a particular transaction that establishes a common basis for their understanding. Maybe they've learned things about each other, how they do things, and they just kind of take it for granted. Course of dealing. Usage of trade. This is any practice or method of dealing having such regularity of observance in a place, vocation, or trade as to justify an exception that it will be observed. So the terms, this is the trade. This is what they do, this is not necessarily the parties' interaction with each other. This is what's common practice in the business that they're in, their commercial trade that they're in. So what's observed? Okay? And the terms are interpreted to be consistent with each other. If unreasonably expressed terms in the contract, if it's unreasonable, meaning it differs. So if the usage of trade is unreasonable to what the terms in the party's actual contract with, it's not going to be allowed. Okay? It's got to be consistent with what's in the contract. And it has to be more than, well, we always did it this way. This is the way it's done. This is the way we always do it. It's got to be more than that. Okay? And if we have, I'm going to do course of performance first. Course of performance, it's the conduct that occurs under the terms of a particular agreement indicating what the parties to an agreement intended it to mean. What do I mean by this? So we have a contract, the parties have their contract, and they're already doing things by their conduct. It may establish what the parties intended. Oh, well, he's doing this and she's doing that. This is because of their conduct and what they're doing. This is clearly what they mean by their course of performance. This is the parties to the actual contract that we're dealing with right now. So course of dealing is past performance, past conduct of the parties in their dealings. Trade is what's common in the particular trade, as long as it does not run inconsistent with the terms of the contract that's being reviewed. And the course of performance, how are the parties conducting themselves under the terms of the contract as they believe, they understand them to be. Now, if a court is determining a term or something regarding the contract, and a party brings in, well, this is what we do in the uses of trade, and the opposite opposing party brings in, well, this is what we do in the course of dealing, the course of dealing is going to kind of trump the trade. Okay? So those are the principles relative to the parole evidence rule. So I'd like for you to go and pull the question, the examples off the separate sheet and review them with these rules and see if you can figure out the answers to A, B, C, D, and E before you listen to the audio regarding that. Okay? Unconscionability, last component of sales and leases. Basically, I'd like you to remember or recall the common law rules involving unconscionability. They apply here under the UCC. Basically, or generally, a contract that is so unfair and so one-sided, it would be unreasonable to enforce it. There is no straightforward definition. No one can tell you what unconscionability looks like. I like to compare it to an obscenity. There was a judge that said, I can't define it, but I know it when I see it. Unconscionability is the same sort of concept. Okay? So generally, it's a contract that is so unfair and one-sided, it would be unreasonable to enforce. Review the section under the common law under here with regards to the procedural unfairness and the resulting contract or the substance unfairness. That's what the courts will review under the UCC as well.